6. Rights and obligations of parent and child. Not only the rights and duties of parents, but also the legal responsibilities which the law places on children have changed greatly since ancient times, when a father had the right of life and death over his children. Interest in the welfare of children has increased as civilization has progressed. Though we still have child beatings, crimes against children, and bad adoptions, we also have laws to protect children and legal machinery provided by the state to enforce these laws. When an infant becomes of age, at common law children were legally infants until they became 21 years of age. This is still true unless changed by statute, but in many states a girl becomes of age at 18, though a boy does not reach majority until 21. The exact moment when an infant becomes of age is sometimes of considerable importance. For instance, when liquor has been sold or the right to vote is in question. The rule is that an infant comes of age on the first moment of the day before he celebrates his 21st birthday. A court will not consider a fraction of a day in reckoning time, so an infant is regarded as born at the first moment of the day on which he came into the world. In an English case, there was a question whether the birthday of a young girl was the 4th or 5th of January, 1805. She was born after the house clock struck 12, while the parish clock was striking, and before the clock of St. Paul's had begun to strike 12. It was held that she was born on the 4th because a house clock regulates only domestic affairs. The parish clock was better evidence, but the metropolitan clock was held as implicit evidence of the time. Custody and control. The most fundamental right which parents have is that of custody and control of their minor children. At common law, the father had this exclusive right against everyone, including the mother, and he could by law or deed give guardianship of the child to another, as against any right of the mother. This is still the law in some states, but in all but 10 the mother and father have equal rights of guardianship, and on the death of the father the mother has exclusive control. In New Hampshire, court held that this joint guardianship continues even after separation. In this instance, the parents were divorced but separation. No order was made relating to the custody of the child. The mother lived in New Hampshire and the father placed the child outside of the state. The decision was that the joint guardianship conferred by statute in 1911 was not dependent upon the continuance of the marital relationship and could only be terminated during the minority of the child by the death of one parent or by a decree of the court. Therefore, while the mother was domiciled in New Hampshire and possessed equal rights of custody with the father, the child's domicile in this state was not lost by the removal of the child to the domicile of the father in another state. The Court of Chancery in England considered the welfare of the child and took the custody from a father who was found to be unfit, unless the child was heir to property. However, the Court of Chancery did not usually intercede, so the fate of the children of the masses still remained in the common law courts. The father's duty to support. At common law, there was no obligation resting upon a father to support his children to the extent that legal action could be taken to force him to discharge this duty. It was held to be only a moral obligation, and even the statute passed during the reign of Queen Elizabeth was restrictive as it provided that no one was under a duty to support his child, except as to necessaries, unless the child was unable to work through infancy, disease, or accident. This duty is now regulated by statute, and usually upon the death of the father it falls upon the mother if she is in suitable circumstances. At common law, a third person who had furnished a child with necessaries could not recover from the father unless he could show that the father had given the child the right to pledge his credit. In an Old English case, the facts were that a father sent his minor son to London with the expectation that he would enroll on Aship. He gave him money and instructed him to stay at a certain hotel while waiting for the ship. But the son went to another hotel which he thought was more economical and nearer the docks. He stayed there for 15 weeks, and then the innkeeper brought suit against his father for his board. The opinion of the court was that a father who gives no authority and enters into no contract is not liable for goods supplied to his son. There might seem to be a moral obligation, but there could be no such inference from a legal standpoint. If parents were living apart because of the father's misconduct, he was chargeable only for the necessaries of the child living with the mother, on the theory that he was responsible for her necessaries, and while the child was living with her he would be responsible for the necessaries of the child also. Our courts are more liberal and hold the father responsible to a third party when the child is away from him. Some jurisdictions have gone so far as to hold the father liable for support after divorce even when no express provision has been made for this. A man deserted his wife and 3-month-old child and contributed nothing toward the support of either. The mother went to live in Colorado, while the father lived in Minnesota. She obtained a divorce in Minnesota and the custody of the child was awarded to her. No provision was made for the maintenance of the child, who became ill with tuberculosis and needed special care. The question involved was, would the law imply a promise on the father's part to pay for the child's care? There is some conflict on this point, and the decisions in some states do not so hold. But by the weight of authority, the father's liability is not impaired by the decree of divorce giving custody to the mother. If he refuses to pay, she can recover, for the law implies a promise to pay because of the benefit conferred upon the child. In the absence of statute, there is no obligation on a child to support his parents. The right to earnings, along with the parent's right of custody, is the right to the services and earnings of a minor child. We find that foreign people and others of poor economic status often avail themselves of this right and insist that a child shall become a breadwinner and help with the burden of the family as soon as he is old enough for this. Probably many children have been started on the way to delinquency by demanding parents who have failed to recognize the child's right to have a small amount of spending money from his own earnings. A New Jersey court upheld a mother's right to the earnings of her child when the father was dead. Action was brought by the mother to recover compensation for the work and labor of her son, a minor who had worked for one Allen at his request. Allen contended that action could not be brought by the mother even though the minor lived at home and was cared for by his mother. The opinion of the court was that the mother succeeded the father in the duty of caring for her son, and she also succeeded to the father's right to his earnings. It is interesting to note that at common law the decision would have been contrary to this. Blackstone disposed of a mother's rights in such a situation by saying that as a mother she was entitled to no power, but only reverence and respect. Emancipation. If a child has become emancipated, the parents cannot recover his wages. Emancipation can be brought about in 3 ways: if a father agrees that the child shall be free from his control, or abandons or fails to support the child, or the child consummates a valid marriage, he is legally emancipated. The question of the validity of a marriage came up in a suit which was brought for unlawfully enticing away the plaintiff's daughter and depriving the plaintiff of her services from March 29, 1879 to September 2, 1882, when she became 21. It was proved that the daughter had been lawfully married on March 29, 1879. The court said that the marriage of an infant, if above the legal age of consent, as she was, is valid though it was contracted in defiance of parental wishes and authority. Therefore, a new relationship was created by the marriage, and the father was no longer entitled to the earnings of his daughter as she was emancipated. There have been other decisions holding an opposite view, but most decisions are in accord with the New Hampshire case. Right to recover for injury. It follows that if the father has the right to the earnings of the child, he has a valuable property interest in the child, and on this interest he can recover for services and earnings if the child is injured or killed. There are really 2 causes of action arising: one to the father, to recover damages for loss of services during the period of illness or sometimes, in case of the child's death, until the child would have reached majority. The other to the child, giving him the right to recover for injury, pain, and personal loss. If a child is too young to work and there is therefore no loss in services, but the injury causes expense for nursing and medical care, the general rule is that the parent can recover for this. If a female child is seduced, the father can recover damages for the shame and embarrassment caused him, as well as for the loss of services, and he has the right of action against anyone who entices his child away. Non-liability for tortious acts. A parent is not liable for the wrongful or tortious acts of his child, even though they involve injury and financial damage to property. Consequently, if a child breaks the windows of a neighbor's house by throwing stones, or otherwise destroys property, there is no legal liability, though the father may feel that he has a moral obligation to pay for the damages. Neither is a father liable if his child takes his automobile without his knowledge, and while driving it runs into another car. A very old case attempted to hold the father liable for the wrongful act of his child on the theory that the child was like a vicious animal, and since the father knew this, he would be liable, just as he would be for the damage caused by a vicious dog. However, this reasoning did not prevail. The father is responsible if a wrongful act is done at his order, for then the child is his agent, and they can be sued jointly, but in general the child is responsible for his own acts and can be sued in the name of his guardian or next friend. The doctrine of attractive nuisances. The rule known as the doctrine of attractive nuisances gives recognition to the fact that certain mechanical devices have an attraction for children. This originated in an Old English case in which the facts were that the owner of a wagon left it standing by the curb, and a small boy got in the wagon and was injured when the horse ran away. The boy was guilty of wrongful conduct and trespassing on another's property, but the court held that the cart invited the small boy and the owner was liable for the boy's injury. Since that time, the doctrine of attractive nuisances has been followed in most jurisdictions, first in railroad turntable cases, and more recently in cases involving automobiles which have been left unoccupied with the engine running. The courts are not in entire agreement on the turntable cases, for a New Hampshire court held that the railroad was under no duty to keep the premises safe for a mere trespasser, and that the trespassers being a child made no difference. This is quite opposed to the ruling of a Minnesota court which held that the child did not occupy the position of an ordinary trespasser. The defendant knew that a turntable is very attractive to children, and when in motion very dangerous, and by leaving it unfastened and unguarded was holding it out as an allurement. The child could not be blamed for yielding to the temptation, so the railroad was liable for not giving protection to the child. The dog yesterday and today. The small boy's friend, the dog, has come in for legal recognition also. Formerly, when a dog bit a man, he was tried and executed. That is, if he was a vicious dog and habitually bit people, he would not be disposed of on the first offense. However, on the theory that every dog is entitled to one bite. Today the dog is not tried, but the owner may be sued for damages, and even then it is necessary to show that the owner knew that the dog was vicious. Criminal intent necessary. It is necessary to have a criminal intent in order to commit a crime. At common law, a child under 7 was presumed to be unable to commit a crime, but between the ages of 7 and 14 it was possible to show that he did intend the consequences of his act, and if over the age of 14 he was presumed to have sufficient capacity to commit a crime. He then had to show non-existence of criminal intent for the wrongful act in order to escape liability. Children as young as 10 and 12 have been hanged for their wrongful acts, both in England and in this country. Property rights of infants. With the father's duty to support goes the corresponding right of the child to receive care and to inherit from the father. At common law, inheritance rights were affected by the feudal system, and at first only the eldest son had the right of inheritance. Later, all the sons were capable of inheriting, but none of the daughters were. In this country, unless there is a will, lineal descendants inherit equally. At common law, an unborn child had no right to acquire and hold property, and so could not inherit if born after the death of the father. This has been changed by statute in this country, and a posthumous child will inherit equally with those born during the life of the father. Liabilities of infants. In order to protect infants while they are inexperienced and immature from the acts of persons who may be designing, the law has placed certain privileges at their disposal. The most important of these is the power to avoid contracts. The general rule is that an infant is not bound by his contracts, and some states hold that however great the benefit received, his infancy is a complete defense. One state at least has held that the infant who has received benefits is liable for their fair value. This is based not upon the contract, but on an implied promise to pay for benefits received. While it seems only right that very young children should be protected and be given the power to avoid the results of ill-considered acts, a different situation arises when a person from 16 to 21 is involved. Then the infancy may be used as a means of defrauding innocent tradesmen who have been deceived as to the true age of the child. An infant is liable if he misstates his age and says that he is older than he is. However, the action then is not based on a contract, but recovery is possible because of deceit. An infant can repudiate a contract anytime before he receives a benefit. For example, if he contracts to buy a set of books, he can disaffirm anytime before receiving the books. The liability of an infant for necessities furnished him again brings up the question of what are necessaries besides food, clothing, and shelter. One court held that when an infant gave a party to his friends at college, this was an indulgence and not a necessity. Taken as a whole, the laws relating to infants present a good deal of inconsistency, for even in the same jurisdiction the decisions have not been uniform. The illegitimate child. In considering the responsibility of parents to their children, we have to consider the illegitimate child also. Some of the earlier civilizations recognized the right of the illegitimate child to inherit property under certain conditions, and what is still more important, to receive recognition from the father. The ecclesiastics tried to introduce into the common law courts the rule that these children became legitimate upon the subsequent marriage of their parents. This was very distasteful to the barons because it interfered with the rights of inheritance, but it is the rule in most states now, and many children have been thus legitimized. At common law, the illegitimate child was looked upon as nobody's child, but had the domicile of the mother. The mother also had custody and was entitled to the child's wages, but until the time of Queen Elizabeth she was not obliged to give support. Of course, the father had no obligation to support, because legally he was not the father. This child of nobody could inherit neither from his father nor his mother, nor could the parents inherit from him, as he had no heirs except from his own body. By statute, in most states he can now inherit from his mother, and in some states where the legislation is particularly advanced he can inherit from his father, though paternity must be established by court procedure. If a woman is married, there is a strong presumption that any child born to her is legitimate, but this may be overcome by convincing proof that her husband is not the father. For example, if he is impotent or has been away from his wife for such a time that it is impossible for him to be the father. Today, most states have statutes which place the responsibility of support on the father, but all too often no action is taken to establish paternity, which has to be determined before liability can be fixed. In some states, the policy of accepting a lump sum settlement rather than a weekly or monthly payment prevails, but since these lump sum payments are generally small, the burden falls in time on the mother or on some agency. Altogether, the illegitimate child has more consideration than in the past. Many states make provision for investigating and licensing foster homes that board illegitimate children. Better physical care is provided by social agencies than formerly, and each mother's problem is considered on an individual casework basis. Many of these children are adopted and bring a great deal of happiness to their adoptive parents, as well as gaining for themselves a sense of security and a legal status.